Today's webinar is titled The ABCs of 104, Understanding Exemption Categories. This webinar is presented by the U.S. Health and Human Services Office for Human Research Protections, Division of Education and Development. A disclaimer before we get started. Any opinions expressed in the course of this presentation are those of the presenter and do not necessarily reflect the policy of HHS or OHRP. Any references to the regulatory provisions in the Common Rule in this presentation have been simplified to facilitate understanding. Always refer to the actual text of the Common Rule available on the OHRP website for a complete and accurate depiction of the regulatory requirements. The hyperlink provided on this slide will take you to that page. Today, we will discuss what exemption means, describe the exemption categories found in the Common Rule, and explain the criteria for the more commonly used exemptions. Now, I know that exemptions can be tricky and difficult to apply, and that regulatory language can even be intimidating at times with its legalese. Hopefully, this introductory presentation can help your understanding of exemptions. In the previous webinars in this series, my colleagues introduced the Common Rule regulatory requirements, as well as some key definitions. When do you have to follow the Common Rule regulatory requirements? When you are engaged in non-exempt human subjects research that is funded by a Common Rule agency. This generally means, from the macro level, there will need to be a formal IRB review, informed consent is required, and the institution doing the research must have a federal-wide assurance, or an FWA. The Common Rule regulatory requirements do not apply if any of the following three items occur. The project is not research, it is not human subjects research, or it is exempt human subjects research, which is what this presentation is covering today. In these instances, the Common Rule regulatory requirements do not apply. In these instances, institutions have flexibility in determining what policies or practices should be followed. But please remember, even if the Common Rule regulatory requirements do not apply, this does not mean that the research is free from any ethical concerns. Here's a quick visual representation of the questions to be asked and answered, moving from left to right, to determine if a study is non-exempt human subjects research and if the regulatory requirements will apply. For the purposes of this presentation, we've determined that the activities are 1. Research, with 2. Human subjects, and we are trying to figure out if it is 3. Exempt. The remainder of the presentation will be spent in the realm of, is it exempt? How do we go about figuring out if a study is exempt, and what does that even mean, right? Well, the Common Rule lists 8 categories of exemptions found in 45 CFR 46104, which we will, of course, get to shortly. If all aspects of a research study fall into an exemption category, then the Common Rule regulatory requirements for IRB review and informed consent typically do not apply. In some instances, a limited IRB review to verify that specific requirements are met may be needed. Let me reiterate this though. If you have a research study that has components of both exempt and non-exempt research, then the whole study will be qualified as non-exempt, and the study must comply with all of the regulatory requirements of the Common Rule. Now, the Common Rule is silent on who should determine if a study is exempt. Institutions usually have an IRB administrator or a designated person to make the determinations of what exempt research is. Researchers are typically not allowed to make their own decisions on exempt research. Having studies go through an IRB office provides another level of oversight for the institution by having an independent party, separate from the researcher, review the research. This also allows those with a specialized knowledge base apply the regulations accurately in nuanced studies. The reviewer should be sure to document how they come to determine that a particular exempt category may be applicable. If an activity qualifies as research and is human subjects, the next step is to ask, is it exempt? To answer this question, we'll look through the categories of exemptions found in 45 CFR 46104 to see if one applies. Exemptions 7 and 8 deal with secondary research and broad consent. Due to the introductory nature of this presentation, these two exemptions will not be discussed. If you're doing prisoner research, your research is not eligible to be exempt. As we discuss exemptions 1 through 6, I'll point out any restrictions or limitations when conducting research with children. With that, let's go ahead and jump into what we've been looking forward to talking about today, the exemption categories. Exemption 1 is for research conducted in established or commonly accepted educational settings. Great, but what are these places? Definitely a school classroom, but also consider other locations of learning, like before or after school programs. For education research, people tend to think of children in K through 12 programs, elementary and high schools. And yes, Exemption 1 can be applied to research with children. But educational settings go beyond this to colleges and universities and even adult education classes. And again, you can really think outside the box here and outside of a classroom too. Let's examine the red highlighted normal educational practices. These can be items such as teaching strategies, instructional techniques, and classroom management. So consider things like how information is presented to students, say orally through a lecture versus writing on a chalkboard or playing a video, or using the Socratic method, in which the teacher asks students a series of questions rather than simply providing the answers to help facilitate critical thinking. These would likely be considered normal educational practices. Another way to think about it is that normal educational practices are activities that would be occurring regardless of whether or not the research is conducted. The exemption requires that the research is not likely to adversely impact the student's opportunity to learn required content. So things that would be distracted or time-consuming would likely adversely impact the course curriculum. And this also extends to the educator's ability to do their jobs too. So it applies not just to the student's learning, but also the teacher's teaching. Something that affects the teacher's ability to teach the students would not be permitted under Exemption 1. Remember to always go through the flowchart questions. We only come to the exemption categories after first determining that the project is research, then it is research with human subjects. The examples in this presentation operate with the understanding that the projects are human subjects research, and we are at that third question, is it exempt? So let's take a look at the first example. A researcher thinks that frequent breaks from learning will lead to better retention of facts. He has a teacher use 5 out of every 20 minutes of a history class to let the students draw anything, not history related, and compare test results to a second class where there is no drawing. Let's apply the Exemption 1 criteria. Is the research taking place in an established educational setting? Yes, the research will take place in a school and a history classroom. Does the study involve a normal educational practice? Yes, the researcher is examining teaching techniques, theorizing that breaks will help students retain knowledge. Is the research likely to not adversely impact the student's ability to learn or the teacher's ability to teach? Probably not. The history teacher must now dedicate 25% of the instruction time to drawing. Not many lesson plans can account for losing that amount of time. To account for this loss, the teacher will need to go through the material faster or simply not cover some of the required learning. Either is likely to have a negative impact on the student's learning. Exemption 1 does not apply in this example. A researcher is curious if medical students can learn from actors with pretend symptoms compared to real patients. She follows 2 groups of students, each learning differently. She observes the students, rating their interactions, and compares their scores on a medical licensure exam. Remember, we're determined that this is research with human subjects, and now we're looking to see if an exemption applies. Is this commonly accepted educational setting? Yes, remember, education research is not only for children but also adults. As a result, education can take place outside of the traditional school classroom. Medical students learn in both in a lecture hall and when interacting with patients. This does not mean that for all students a patient's room would be considered a commonly accepted educational setting, but for medical students it is. Does the research involve a normal educational practice? Yes, these two medical schools have established curriculums that incorporate patient interaction as part of their medical students' learning. Note that the schools have these programs already, and that a researcher is examining how they compare, or like how effectively students can learn from actors versus patients. Is the research likely to not adversely impact the required learning? No, the research is not likely to adversely impact the learning. The students are doing exactly what they would be doing otherwise, and the researcher is just observing, making notes, and using exam scores to help with her analysis. The exemption probably does apply. Let's look at Exemption 2. You'll note right from the beginning of the text, the types of research interactions are limited. Exemption 2 only applies to educational tests, surveys, interviews, and public behaviors. These are interactions. Interventions do not fall into Exemption 2. Educational tests would be things like the SAT and ACT, but also placement tests to determine if a student should be placed in an advanced or intermediate class. The term survey, as used here, refers to information collected about individuals through questionnaires or similar procedures. An example of a survey would be the current population survey conducted by the U.S. Census. This definition of survey is limited to information. It does not include collection of biospecimens. Interviews can be individual, but also include things like a focus group. Public behavior is included as well. When you're outside in the public, your behavior can be observed by anyone, so research observation is not inappropriately intrusive. The exemption can be used if the information is recorded in a manner such that the identity of the participants is not known or cannot be readily ascertained. The second provision allows a researcher to retain the identity of the subject in the data or information collected, so long as release of this information will not place the subject at risk of, for example, criminal or civil liability, or that might cause damage to the reputation or employability, things of this nature. In other words, the information recorded is not sensitive so as to cause harm to the participants in the event of a disclosure. The third provision allows for identifiable information to be recorded, even if there's sensitive information, if there's a limited IRB review, which I'll discuss on the next slide. By now, you're probably wondering why there are red, bolded, asterisk phrases, right? These Category 2 provisions are prohibited for research involving children. Children may not be surveyed or interviewed. This exemption for children is limited to educational tests or the observation of public behavior when the investigator does not participate in the activities being observed. Exemption to Provision 3, I'll say it again, is not applicable for research involving children. The limited IRB review requirements are designed to provide privacy safeguards to reduce the chances that the disclosure of identifiable private information will occur and lead to harm. The privacy and confidentiality protections are examined to ensure that they are adequate enough. The reviewer should only consider the particular conditions needed to meet this exemption. The reviewer should not look to the review criteria found at 46-111. The reviewer could be an experienced IRB administrator who's also on the roster as a member of the IRB. For institutions that do not have their own IRB but rely on an external one, it's a good idea to have an arrangement of how to do this with the external IRB from the beginning. Remember, if the research project is not funded by HHS or a common rule agency, or if the federal government has no jurisdiction otherwise, then most likely be a matter of institutional policy for how to handle these determinations requiring a limited IRB review. This may proceed through expedited review. Continuing review is not required for studies that qualify under Exemptions 2 and 3, meaning that there's no annual requirement to evaluate the study. But please note any changes to the study that alter certain elements, such as the identifiability of the subjects or manner in which data is recorded, may trigger a new review and determination. Just because an activity is initially determined to be exempt does not mean that it will always be exempt. The criteria must be continuously met. Let's look at an example. A researcher is interviewing adults about their prescription drug addiction. The information is recorded without any personal data. Are interviews allowed under Category 2? Yes, interviews are one of the permitted interactions. Do the data readily identify any of the subjects? No. Any identifiers are stripped and the information is published in the aggregate, so there is no link. Exemption 2 would likely apply here. Remember, between the provisions there is an or, meaning that only one of the three has to be satisfied, and you have the ability to pick. Now, the researcher wants to include children. Is this type of interaction allowed with children? No. While Exemption 2 covers interactions such as interview procedures, as we just saw, when children are participants, the interactions are limited only to educational tests or the observation of public behavior when the investigator does not participate in the activities being observed. Survey procedures and interview procedures are permitted under Exemption 2 only for adults. Exemption 2 would likely not apply here. Here we have the same fact pattern as before, but now the researcher wants to attach a non-invasive heart monitor to see if certain questions have an effect on the subject's heart rate. When applying Exemption 2, we're given a list of activities. Does adding permitted activities, does adding a heart monitor fall within these? No, the regulation limits interactions to educational tests, survey procedures, interview procedures, or observation of public behavior. We do have an interview, but the study must be looked at as a whole, and all aspects of the study must comply with the exemption requirements. Measuring heart rate is not an interaction, but rather an intervention. If you recall from last week's webinar, an intervention includes both physical procedures by which information or biospecimens are gathered and manipulations of the subject's environments that are performed for research purposes. Here, the attachment of a heart monitor qualifies as an intervention. Exemption 2 can be used for only a limited type of interactions. Exemption 3 is for benign behavioral interventions, which I will explain shortly. But before that, why it's hopefully fresh in your memory, I want to point out that Exemption 2 and 3 have the same review criteria. The regulations outline format is slightly different, and that's why I've labeled them with the letters A, B, and C for number 3, as opposed to the Roman numerals I for Exemption 2. But very briefly, the information in the study is recorded so that it cannot be readily linked back to the subjects, or the information is not sensitive, meaning that there is a low risk of harm should there be a disclosure by the study team, or there are identifiable and sensitive information, but there's a limited IRB review for privacy and confidentiality protections. Exemption 3 does not apply to research involving children. So if there's ever an intervention with children, no exemptions will apply. When there are certain types of interactions with children, Exemption 2 may be applicable if all of the criteria are met. There's a lot to unpack here. Exemption 3 is for research with adults involving benign behavioral interventions with collection of information when subjects agree to the procedures prior to the research. Immediately, this can be distinguished from Exemption 2 because it includes interventions in addition to interactions. But what is a benign behavioral intervention? Benign behavioral interventions are first brief in duration. This is not apparent from the word benign. Data collection is allowed to take longer, but the intervention itself is short. What is probably more familiar and obvious from the word benign is that the intervention should be harmless, painless, not physically invasive, and not likely to have a significant adverse lasting impact on the participants. So in these types of interventions, we are not expecting any physical or emotional harm. There should be no persistent, long-lasting effects. The researcher should have no reason to think that the participants will find the interventions offensive or embarrassing. The researcher has to consider the target population. Think about particular sensitivities of the research group being studied. Be sure to take into account potential cultural as well as generational differences. You'll notice in the root that data collection is bolded. Exemption 3 can be used if data are recorded through verbal or written responses, so interviews and surveys are permitted. One thing that sometimes trips up reviewers and researchers is the audiovisual recording. It is permissible to videotape or audio record participants under Exemption 3. Now, people are sensitive about being videotaped, so please do consider mentioning that to prospective participants when you ask them to participate. You'll notice that what is absent, however, is any sort of physical biomedical collection mechanism. In my last example, attaching a heart monitor would not be appropriate under Exemption 3 because of the manner in which data is collected. A researcher could, however, ask if a participant had a faster heart rate because that would be a verbal response. Lastly, there has to be prospective agreement, meaning that prior to the study, the participant must provide meaningful agreement that is not coerced. Potential participants must be able to agree to take part in the research, and therefore they must have sufficient decision-making capacity to do so. The level of cognitive ability required will vary depending on the complexity of the intervention proposed. Prospective agreement may occur orally. It does not need to be given in a signed document. Now, this is not the same as the regulatory requirements for informed consent and documentation of consent found in the Common Rule. Exemption 3 actually includes a provision for deceptive studies. In these studies, the subject must agree to the deception ahead of time and be told that they will be deceived in some regard, that the subjects are informed that they will be unaware of or misled regarding the nature or purposes of the research. Again, prospective agreement does not mean that you need to obtain informed consent as dictated under the regulations at 46-116. A simple but voluntary, remember, free from coercion, and meaningful and prospective agreement is sufficient. Okay, let's review an example to test your skills. Adults are asked to complete 2 games of Sudoku in both a quiet room and then a room with a white noise machine to see if there's any difference in their behavior. They are interviewed afterwards so the researchers can see if there were positive or negative effects completing the puzzles. Is the activity a benign behavioral intervention? Let's examine the 3 criteria. Is it brief in duration? Yes, the amount of time it takes to complete 4 games of Sudoku is relatively brief. It might vary from person to person, but this is not an all-day event. The time will be measured in minutes. This is permitted. Is the intervention harmless, painless, not physically invasive, and will have no long-lasting adverse effects? Yes, the intervention is solving a puzzle in silence and then with white noise. A participant's environment is manipulated through the introduction of white noise. Listening to white noise will not cause any harm, pain, or long-lasting adverse effects. In fact, white noise is frequently used to help individuals sleep. Is asking someone to solve puzzles in noise and silence offensive or embarrassing? No, a researcher would have no expectation that the subjects would find this activity offensive or embarrassing. It's likely that puzzle solving would be considered a benign behavioral intervention. Are the interviews a permitted form of data collection? Yes, verbal responses are allowed under Exemption 3. Is there prospective agreement? Yes, in our fact pattern we are told that subjects are asked to participate. By design, the fact pattern is simple, so for our purposes this works. The individual who is making the exemption determination would likely want some more detail. Are the identities of the subjects readily ascertainable? Similar to above, we don't know here. Absent any language stating that there are no identifiers attached to the data, we should proceed that there may be. As a reviewer, the protocol should be explicitly state whether or not there are identifiers attached, or if the identities of the participants can be readily ascertained from the data. Since the exemption has an or between each provision, we can proceed to the next criteria. Would responses to questions about Sudoku and white noise harm subjects if disclosed? Probably not. I'm unaware of any criminal or civil liability that could result. It would probably be a real stretch to say that someone's reputation would be affected. Exemption 3 is probably appropriate for this study. Even though we're unsure about whether the identities can be readily ascertained, the second provision likely lets a reviewer determine this is exempt. A researcher asks subjects to play video games where they'll match objects in a timed environment. The researcher videotapes their eye movements to see the speed with which they move as time runs out to finish the game. Moving through the main part of the exemption, playing a computer video game would likely qualify as a benign behavioral intervention. It's short, it's not going to harm anyone, and it's not offensive. We also know that videotaping is a permissible form of data collection. Next, would one of the three provisions apply? We don't know about the participants' identities, so looking at provision number 2, would a disclosure of the information collected place the subjects at risk? Probably not. It's hard to imagine a situation where eye speed movements would affect someone negatively if disclosed. Since the second provision is satisfied, it does not matter whether or not the identities are known. Exemption 3 would likely apply here. Now the researcher is interested in monitoring their heart rates. Surely as time runs down, there should be a change in beats per minute. Is this a permissible form of data collection? No. Even though not invasive, this is not a verbal, written, or audiovisual recording of data. This is a recording of data using a physical intervention, the heart data monitor. Exemption 3 will not apply in this additional situation because of the usage of the heart monitor is not permitted because it's an intervention. Adults are asked to watch a short video on clinical trials and will be interviewed afterwards to see if it affects their feelings about research. The point of the research, however, is to study behavioral reactions as the temperature is lowered in the room. Ooh, intrigue. We can tell that this is likely a benign behavioral intervention as participants are watching a video about an offensive material. We also know that interviews are a permitted form of data collection. Is there a provision that would work here? What about the second provision that allows for identities, but only if a disclosure would not harm the individuals? Worded differently, is a disclosure likely to cause harm? No, there's nothing to suggest that a disclosure of the information would be painful, harmful, long-lasting, or for that matter, that the researcher has a reason to believe that the subject would find the movie or questions offensive or embarrassing. However, we have an interesting wrinkle here. The study is deceptive because the actual purpose of the study has been hidden from the subjects. So has the subject authorized the deception? No, the subjects have not authorized the deception. They are asked to watch a video on clinical trials and then interviewed about that topic. There is nothing stating that the subjects know they will be deceived during the study. Exemption 3 would not be applicable in this situation because the subjects have not authorized the deception. Had the researcher told the subjects that they would watch a video and answer questions, but that the real point of the study was actually something else, and they agreed to this beforehand, the deception would have been authorized by the subjects. Exemption 4 is for secondary research that does not need consent. But what is secondary research? It's using information or specimens that were originally collected for another purpose. What are some of these other purposes? One example could be a blood specimen that is originally collected for medical standard of care safety diagnostic tests. The primary purpose and collection of the blood was for safety tests. The leftover sample may be eligible to be used in a research study. But medical treatments are not the only source. A research study collecting blood to see how effective a new pharmaceutical is in treating rheumatoid arthritis could be stored and then later used in a separate study looking for biomarkers in arthritic individuals. The point is, the specimen was originally collected for another purpose other than the current research study. Remember that identifiability relates to individuals who are known, but also applies to those who are currently not known but could be readily ascertained by the researchers. Maybe readily ascertained means that there exists a link between the data and the subject that the researcher can figure out who the subject is. If there is secondary research with non-identifiable samples, then this is not human subjects research, and there's no need to look for an exemption category because the common rule regulatory requirements do not apply. Always remember our questions. First, is it research? Second, is it human subjects research? And only if we answer yes to both do we look to the exemption categories. If the researcher is interacting or intervening with living individuals to collect their materials specifically for the proposed research, then this is actually primary research, and Exemption 4 would not apply. Now that we've discussed the definitions, let's examine the Exemption 4 criteria. This type of research is exempt if the material being studied, information or specimens, are from a public source. This could be using information from an internet web page that is open to the public, either free or at a nominal cost. Access is what we are evaluating. Access at a cost is still permissible. The source can be from a commercial entity if the information is provided to members of the public on request, or if the only requirement for obtaining the information is paying a user fee, registering, or signing in as a visitor to an archive. So a possible source could also be with information obtained from the National Archives in Washington, D.C., which actually currently requires a reservation. Source of biospecimens could be a commercial biobank that charges per sample. The point is the public at large can access the information or specimens even if there's a sign-in requirement or payment. The question is one of public access. Next, even though the information or specimens are starting off as identifiable, the investigator must record the information such that the identity is not readily identifiable, and the researcher must not contact the subjects or re-identify them. Contacting the subjects constitutes at least an interaction, and this would remove the research from being secondary research. Importantly as well, the investigator must not attempt to identify the subject. The third provision is if the investigator is doing research at a HIPAA-covered entity. HIPAA, or the Health Insurance Portability and Accountability Act of 1996, is a federal law that requires adherence to national standards to protect sensitive patient health information from being disclosed without the patient's consent or knowledge. In these cases, HIPAA governs the research. An investigator can maintain the identities and perform research on this information. HIPAA's privacy rule governs the research, so simply follow the HIPAA requirements. But this provision is only for information. It is not for biospecimens. The HIPAA provision of Exemption 4 can be a very complex issue. If you're interested in learning more, please go to the OHRP Luminaries page to hear a discussion by Mark Barnes. In the last provision, the information is government generated for non-research purposes. This speaks to the secondary use component of Exemption 4. And the research is conducted on or behalf of the federal government, and federal privacy standards will apply. So the research may be done by a government contractor or at the direction of the federal government. Exemption 4 can be used on research with children. Let's look at an example. A researcher stores blood with identifiers from old clinical trials. She thinks that there may be a link between prostate cancer and nickel. To test her hypothesis that there is a link between nickel in the bloodstream and prostate cancer, she requests 100 samples from an assistant who removes the identifiers. Let's apply the Exemption 4 criteria. Is this secondary research? Yes, the samples were originally collected for another purpose, a previous clinical trial. The researcher will not interact with any of the participants, let alone engage in an intervention like collecting new blood to test this theory. Now, is there a provision in Exemption 4 that would work? We can tell that the samples are not publicly available, but what about that second provision? Is the information from the samples recorded in such a way that the identity is not known or cannot be readily ascertained? Yes, the assistant provides only blood samples to the researcher without any information attached. With no log maintained, the identities of the men who donated these specific 100 samples are unknown and cannot be readily ascertained. It might be true that with some determination and sleuthing, the samples could be re-identified, but this would be a great effort to undertake, and this process is beyond what would be considered readily ascertainable. Lastly, will the investigator try to re-identify or contact the subjects? Even though the investigator, as well as the assistant, does not know who donated these specific 100 random samples, she does know of everyone who has contributed samples from her previous studies. The assurances to not contact and to not re-identify are not clearly given. Determination reviewers should look for these specific guarantees in the protocol that re-identification of the samples will not occur, nor will the men be contacted. Exemption 4 may apply through the second provision if the researcher will not re-identify the samples and will not recontact the men. We have the same fact pattern as before. Only this time a log is maintained identifying the men, but the researcher will not have access to it. The researcher herself will not know the identities of the men and will not contact them. We've established that this is secondary research and the samples are not public. Is the information recorded in a manner that the samples are not identifiable? No, a log is being maintained that clearly links the identity of the men to each sample. Delegating this duty to other members of the team does not permit this research to be allowed under this provision. Information known to agents acting on behalf of the researcher is also attributed to the researcher. We can end the analysis there. But the study would also fail on the fact that the researcher wants to re-identify the samples and then contact the subjects. Even if the researcher is working at a HIPAA-covered entity, this exemption would not apply because the research covers biospecimens and the HIPAA provision is only for information. Exemption 4 would not apply. In fact, the study would be considered non-exempt human subjects research and the common rule regulatory requirements would apply, meaning IRB review, consent, etc. Exemption 5 is a less frequently used exemption. It's for research studies or projects that look to study, evaluate, improve, or otherwise examine public benefit or service programs. This research must either be conducted by a federal agency or supported by one, which is typically funded through a grant. In other words, the government is conducting this research directly or giving money to a non-government entity to do this research. Additionally, these research projects must be listed on the agency's website before the research begins. Exemption 5 may be used with children. Let me verbally give you a quick example. The Centers for Medicare and Medicaid Services, CMS, want to evaluate a CMS program that reimburses beneficiaries for nursing care at home. The CMS coordinates with a local university to complete this research study and funds it through a grant. The study is posted on a CMS website about 6 months before the research commences. Is this the type of relevant research outlined in the exemption? Yes, the study is evaluating a service benefit program. Is the research fairly conducted or funded? Yes, it's being funded through a federal grant. Lastly, we were told that it fulfills the third requirement by being posted on a federal website prior to the study. With this exemption, if it applies to your research, you will know about it. The main misconception occurs from researchers trying to fit this research into this exemption category without meeting the criteria. Exemption 6 is for research involving taste and food evaluation. The focus here is on the food, not the behavior surrounding the food, like eating habits or studying how the body metabolizes food, etc. I'll say it again. The research must be about the food itself. The food should be wholesome without additives such as a vegetable or fruits, or the food contains additional ingredients such as preservatives or coloring, but these chemicals are at or below a level that the government has deemed as safe. Exemption 6 may be used with children. A researcher is interested in figuring out children's taste preferences so she can advise schools on which yogurts to include in their lunch programs. The researcher plans on taking 5 brand name yogurts that are available for purchase by anybody in grocery stores. She will give 5 different samples to 500 children and ask them to rank the taste of each yogurt. First, does Exemption 6 apply to children? Yeah, I just mentioned that. But it's always a good question to ask when you have a vulnerable population. Next, is this a food evaluation? Yes, the researcher is giving yogurt to children and asking them their preferences according to taste. Note that the researcher is not asking about any behavioral questions or anything else. It is a taste study. Is the yogurt considered wholesome without additives? The yogurt is likely to have added ingredients to prevent it from spoiling or to maintain or alter the texture, but without more information, we should look to Part 2 because the regulation has an or in it. Has the yogurt been evaluated to make sure that the additional ingredients are at or below the safety level established by a relevant government authority? Yes. The FDA and the USDA are responsible for making sure that food is safe, wholesome, sanitary, and properly labeled. The availability of the yogurts in the stores means that it has been vetted by the proper government authority. I know that this might not be entirely obvious, but this is the case. This research would likely be considered exempt through Category 6. A researcher wants to see if how lunches taste at school will affect how children eat at home. Children are asked to evaluate the taste of food and then take a survey to detail what they eat at home. We know from the previous example that Exemption 6 does apply to children. Is this a study evaluating taste and food quality? The study must be looked at as a whole. There is one component that is evaluating taste, but another evaluating behavior through a survey. Remember, all aspects of a study must meet the criteria in the exemption category. Because of this additional interaction of a survey evaluating behavior, the study as a whole fails to qualify under Exemption 6. Exemption 6 does not apply here. Not only are the non-exempt flowcharts available on our website, but we also have flowcharts to guide you through each provision of each exemption. These are a great free resource that anyone can download and use. Lastly, hopefully you found this presentation helpful, but it's unlikely that I've answered all of your questions. Perhaps I've even given you more. Please do email us at ohrp@hhs.gov with specific inquiries, and someone from our office will respond. All of our resources are available free of charge. We have materials that you can use for education and outreach for the general public. We have helpful mini tutorials as well as a more extensive 5-part fundamental human research protection training. Our About Research participation content is perfect for anyone considering whether or not to participate in research. Thank you very much for your time and attention. I hope that this presentation was beneficial for you.